Morning, everyone. Thank you for joining us, and sorry about the delay here. As mentioned, my name is, and I'll be presenting today. And basically, I am going to talk about some of the HR risks that are involved in any business, and I'll try to specifically speak to those in the hospitality business. I think something we all know, especially after the more recent elections and all the rhetoric that went on for the last few weeks, that the federal government definitely needs money. And they actually estimate that about 70 to 90% of all small businesses in the United States are out of compliance. I've had the privilege of working for a very large corporation for 24 years, and I can tell you that there wasn't a year that we weren't dealing with some government agency on some federal regulation. Well, today it's all about the low-hanging fruit, and that is the small business. So the feds have basically targeted small businesses as an additional stream of revenue to make up for some of their current deficits. So these are the topics that I'm going to talk about this morning: contractor versus employee, exempt versus non-exempt, I-9s and E-Verify, OSHA Compliance, some areas of equal employment opportunity litigation that happens to be very hot today, a little bit about the Family Medical Leave Act, some things you should be doing if you have 401k plans for your employees, and of course I'm going to touch a little bit about the Affordable Health Care Act that is now in progress. All right, the first one is contractor versus employee. And what's important to know about this is there are a lot of businesses that have classified people as as a contractor, and they should be classified as an employee. So we're going to take a look at what constitutes employee versus contractor. All right, so I have a 14-point checklist. And I'm not going to go through all of these in detail, but I am going to highlight the first 4. Those are the ones that you see in red. Independent contractors. If the person that you have as a independent contractor, 1099, W-9, can make profit or suffer a loss based on the job opportunity that they're doing for you, then most likely they could be a contractor. The second part is, does the worker have an investment in the equipment and or the facilities used to do the work? Does the person work for more than one company? And does the worker offer services to the general public? They hit into these 4 categories, almost always they will be considered a contractor. Now, it doesn't necessarily mean absolute, but those are some of the key areas that are required to be a contractor. There's also some other areas, and I won't go into those into any detail, but do you have the right to give the worker instructions? Do you train the worker on how to do the job in a particular way? Those types of things. Are the worker services important to your business that they're almost a part of your business? Must the worker provide the services personally, or can they hire someone? Do you have to supervise the person or pay their assistance? Is it an ongoing relationship, meaning it's going to be for the next 5 to 6 years? Do you set the person's hours? And I know that's a tricky one because most likely you do require them to work set hours. Must the worker spend all the time on your job? And of course the last 2, must the individual work on your premises? And do you have the right to determine the order in which services are performed? So some of those are pretty fuzzy. I would say 5 through 14 are kind of fuzzy. It can go either way. But the first 4 are very critical. And actually, if you're caught with someone who is really an employee versus a contractor, you could be subject to overtime and back pay, not to mention all the other taxes and benefits that you normally give an employee. You may have remembered about 10 years ago, Microsoft actually had that same issue. The second one is exempt versus non-exempt. It's pretty easy when you first start out to classify someone as exempt, and in many cases that person may be exempt based on the number of tasks and responsibilities that they have to perform. But in time, with the Division of Labor, they may end up being non-exempt. So we're going to go through what is the salary test that the Department of Labor looks at. The first one is they must make at least $23,000 or almost $24,000 a year, except in the state of California, as you can see, it's $33,000. They must fit into one of these three categories, either an executive, a professional, or an administrative. An executive is pretty easy. That means they manage a department, a function, or a division, or some type of group. And they have the ability to usually hire, fire, or recommend hire, fire, promote, or evaluate. Professional is a category where you need to go to school for some extensive amount of time to get a specific degree, such as a doctor, a dentist, a professor in college, a scientist, a CPA, and actually also in that area is considered to be outside sales, which actually could be a category. And then the fourth one is administrative. Now, administrative is really where most people dump all their what I call exempt employees into. They're not managing the business per se. They're not a professional, but they fit into the administrative piece. So that's usually where your HR people, your marketing people, your office managers, etc. fit into. All right, so there are a couple things that need to happen if a person is considered to be administrative. So that third category. The work really needs to be related to management of the business or directly to the customer. And actually 25% of the person's responsibilities cannot be routine, administrative, and manual work type tasks. The person also must be able to make some kind of discretionary judgment about what's going on. Meaning they have some guidelines, but they're able to deviate from that guideline. They don't necessarily have to check with their boss before they make that decision. And then they say it should be in matters of significance, meaning the decisions that they make should involve profitability or productivity of the business. Some common misclassifications would be administrative assistants, executive secretaries, often shift leaders, like within a restaurant, or technical support staff. Another big area of low-hanging fruit would be the I-9s. Now, I will tell you that I-9s have been a challenge for many employers since its implementation in 1986. In 2013, I-9s are actually going to go to a whole new level. It's going to go from a simple one-page form to basically 2 pages, and going from 4 pages of instruction into 6 pages. So it's going to definitely be a learning curve for everyone once they are implemented. Interesting fact, the government collected over $50 million in fines last year from employers for improperly completing I-9s or missing I-9s. So some critical areas of success for I-9s is they should be completed 100% in ink. They should be completed the first day of employment. They need to be signed and dated by the employee the first day of employment, as well as the employer can only use non-expired documents. And if there is anyone who may have a temporary document, working permit, it needs to be reviewed and renewed within 6 months of its expiration. A best practice that I always recommend is use of E-Verify. It's free to the employer, and it's easy to use, and it basically justifies whether or not that Social Security number is a good Social Security number. It is voluntary. If you're in the state of Georgia, it's actually required if your business has 100 or more employees. Next year, it is actually going to be 10 or more employees in 2013. And if you have a federal contract with the government, it's required. OSHA is also very active, and I know that many of you have probably experienced OSHA visits, usually mostly from employee complaints, but they do happen. There are some key areas that every business should take care of. One of those would be having the proper training and posting, and that employee training is called hazardous communication, or often it's referred to as right to know. And part of that training actually includes training of MSDS sheets. And so all material safety data sheets, that's all chemicals within a business, should be on file. The third area is emergency evacuation. Every business should have an annual emergency evacuation drill for all of its employees, and most importantly, it should be documented. OSHA record keeping, there's certain OSHA record keeping areas, and I know everyone will have an opportunity to get a copy of this presentation. But the first report of injury, monthly log, and the annual summary. And as you can see, the risk can be significant. For every missing injury report that's OSHA reportable, it will cost you $1,000. These are some average fines that have happened in the last year. And I point out in red 3 that are very easy, and they pertain to the hospitality business. That's the hazardous communication right to know, having the employee training, and the evacuation plans. EEO litigation is also on the rise. The Title VII was created in '64. The EEOC Commission was created in '65. As you can see, we actually have more EEOC complaints today than we have ever had before. Basically, what that means is the government is not turning down anything. They're taking on any and everything. A lot of these complaints have been because of loss of job, and that's just kind of spurred it on. But the 4 major areas are employment interviews, terminations, sexual harassment, and age discrimination. And I could actually spend all day on any of these topics, but I know our time is very short. So with respect to employment interviews, the importance here is that they're consistent. All the questions asked are legal. Managers should be trained to professionally interview people and ask questions. Job descriptions should be used in order to make sure that the candidate sees the essential functions of the job. And they should be used to select the best candidate. So best practices are to train your managers to use a standard interviewing format, select on qualifications, and as we say, never write notes on the application. That can get a person in trouble. It has gotten many businesses in trouble. Almost similar things in the area of best practices for terminating an employee. Performance evaluation should be aligned to terminations, unless it's a flagrant violation of some policy. Train your managers on how to document and discipline. The EEOC primarily looks for a minimum of 2 written, signed documents of discipline on an infraction. 2 written documents. If the discipline isn't written, it doesn't exist. And if it's not signed by the employee, it doesn't exist as well. Sexual harassment complaints are also on the rise, which really seems like that's surprising since this has been around quite a bit of time, and it's not that difficult to interpret what sexual harassment is. But some best practices here is to make sure you have a policy, and I always say make sure that the policy that you communicate is in the front of your employee handbook, not in the middle, nor not in the back. Enforce the policy and make sure you have a signed document acknowledging that the employee has reviewed the sexual harassment policy. FMLA, also very important. It was actually amended in 2009. 50 or more employees, and an employee must work 1,250 hours on a year. So if you have 50 employees, if you have 49, know that you're going to go to 50, you probably want to have an FMLA policy in place. The big target on the 401k plans of recent has been that employers, in many cases, have created a plan, which is great, and the employees are participating. They have an investment policy because the plan fiduciary or administrator is going to make sure that you do have one, but they don't follow the investment policy. And when the investment policy is not followed properly, that leaves the employer, who is part of that fiduciary, responsible for the losses of the employee. So it's very important, and here's some best practices here that make sure that the fees are disclosed. You review the investment fees and the performance of the investments at least annually, and maybe even semi-annually. Last but not least, the Healthcare Affordable Act, or for many is the Unaffordable Act, was upheld this year. It goes into effect in January 2014. If you have 50 or more employees or 50 full-time equivalents, so you could actually have 40 full-time and 20 part-time, that equals 50 full-time equivalents, you are required by law to have health care policies, have a health insurance for your employees. Many small businesses, especially in that 50 to 75 range, have a very difficult time of doing that. Often, as you probably may know, and maybe in your case, you may have a benefit, but it doesn't really cover that much of the employee. It's a partial. Well, the Fed, in the Health Care Act, it actually has given some minimums. I actually recently talked to a restaurant that had 75 employees, and they weren't even paying attention to this. And I said, you know, in a year from now, you're going to have to pay. And the minimum for not having it is $40,000. So that business is going to pay $40,000 a year, which, where is that going to come from? That's going to come from their menu, I guess, in addition to their current expenses and penalties, or provide health care to meet the government's. And then that $2,000 for each employee over 50. The plan must cover at least 60% of their health expenses. It cannot exceed more than 9.5% of the person's salary, and the coverage deemed substandard penalty goes to $3,000 an employee if you have a policy that's not up to speed. So as you can see, that's something you really should have your eyes on. It's actually an individual mandate, so everyone must have insurance, whether it be an individual or an entrepreneur, or suffer the penalty unless they fit under a certain salary range. All right, so what we do is we help businesses get their house in order and basically help them mitigate risk. If there's anything that you may have heard today, we certainly would love to talk to you about it. I'm going to open it up to questions. We actually have a membership program that starts at $500 a year, which gives you an opportunity to ask questions on any of the issues that we talked about or any other people or compliance. We also work as a part-time HR director with fees starting at $1,000. And because I do want to open up to a couple questions, I'm going to do that now.
Gary, very informative presentation. I encourage any of the listeners that if they do have a question, just go ahead and post it in the chat section, and then any questions that we receive, we will I'll pass on to you and let you go ahead and answer them. Also, I'd like to give everybody if it's okay, your email address if they want to contact you directly. It's Gary at the virtualhrdirector.com, and they can also visit you at thevirtualhrdirector.com on your website. Again, on behalf of Travlinks, and I think it's a very informative presentation, and if anybody has any questions, go ahead and please start asking your questions now. Thank you. We will send a copy of the PowerPoint presentation out to everybody that was in attendance, as well as we will have the presentation live up on our website probably next week, since this is Thanksgiving week and we are a little light in staff. The person that usually does that is not here right now. We usually try to have it up within 24 hours, but in this instance, I think it's safe to say we'll just have it posted next week.
Okay, Bill, doesn't look like there's anything coming through, so
So with that said, if anybody wants to get in touch with Gary, they can also contact us here at TravLinks. And also, I want to bring to everybody's attention that that the In Touch forums for 2013, instead of monthly, we will be presenting quarterly. And if you have any ideas on topics you would like to have presented, please email them to us at marketing@travlinks.com. That's marketing@travlynx.com. And we will look at getting your suggestion put on to the In Touch forum. Gary, again, thank you for your time and your presentation. I thought it was very informative. With that said, everybody have a great Thanksgiving and a good rest of the day. Bye, everybody.
thanks, Bill.